Okay, you guys, I am back in reference to the YSL trial and what is going on. Yesterday, Mr. Stills, at the end of the court day, gave the judge and also the prosecution team some filings that he did. And here it is. I have it. So let's get into it and see what is going on. Okay. Motion to disqualify Judge Glanville from all further dealings in the above referenced case and motion for which was goaded by the improper conduct committed by concert by the court and prosecution. Comes now Jeffrey Williams by and through undersigned counsel and hereby files this motion to disqualify and recuse Judge Glanville from all further dealings in the above referenced case. A motion for mistrial which was goaded by the improper conduct committed in concert by the court and prosecution in support of this motion. Mr. Williams shows as follows. 1. Undersigned counsel representing Jeffrey Williams in the above referenced case, the jury trial of multiple accused persons commenced on January the 4th, 2023, before Fulton County Superior Court. Judge Glanville, the trial is expected to last at least through the end of 2024. Okay, let's go down and see what 2 is saying. Okay, so number 2, on Monday, June the 10th, within 5 days of the filing of this timely motion, this court, along with the prosecutors, engaged in an unlawful, improper ex parte meeting with, among other persons, a sworn witness, Kenneth Copeland, which they call Woody, for whom an order of use immunity had been issued on Friday, June the 7th. No notice of this ex parte meeting was provided to any attorney for any of the criminal accused in the case. In fact, the accused and their counsel were in the dark that this Star Chamber meeting occurred. Mr. Copeland has previously been called to testify on Friday, asserting the Fifth Amendment privilege in open court in front of the jury and was held in contempt. And then he was incarcerated until such time as he agreed to testify. Judge Glanville and the prosecutors essentially admitted by silence and by statements in open court that an ex parte meeting occurred on the morning of June the 10th, only after undersigned counsel revealed, based upon information and belief, that this meeting occurred. So they basically wasn't going to say nothing, and they thought they had got away with it. Okay, number 3, at the earliest opportunity on the afternoon of June 10th, the court was informed, upon information and belief, that the ex parte meeting with the sworn witness, Kenneth Copeland, and the prosecution occurred earlier that day, and that the witness had made factual admission and that statements were made to the witness by the court and the prosecutors acting in concert about the amount of time Mr. Copeland could be held in custody on the contempt. The court denied undersigned counsel request for the transcripts of the ex parte meeting and denied the timely motion for mistrial. Based upon this improper and illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process and a fair trial, ethical prosecutors, and the right to be present at every critical stage of the proceeding under the Georgia Constitution. Okay, so basically now it's just showing cases. Let's go down. Okay, it's saying the same thing. Let's go down. Okay, let's see. Okay, 10. The court issued a written order of contempt and incarceration for Brian Steele, imposing the maximum sentence of incarceration for 20 days. Okay, so that's when, after he took, basically Steele told him he knew what happened, this little private meeting, and the judge, instead of going over that, he was like, "Who told you? Who told you? If you don't tell me, I'm going to throw you in jail." And he wouldn't tell him. So, yeah. Okay, so 11, okay, that's nothing. That is just repetitive. Okay, 12. The court violated the law by failing its duty to recuse from proceeding over this contempt proceeding. So the judge shouldn't have held, when he put him in contempt, he shouldn't have been over that, basically, is what it's saying. In such proceedings where the announcement of punishment is delayed and where the conduct was directed toward the judge, or where the judge reacted to conduct in such a manner as to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney opportunity to be heard, must be conducted by another judge. Here, the court involved itself in those proceedings by joining the prosecution team and conducting the ex parte meeting that violated Mr. Williams' rights. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of this issue. The court then compounded its abuse of power by proceeding over the very contempt hearing where its own rules violation prompted the controversy. The court should have reaccused and allowed the contempt proceeding to be held by a separate court. Yes, and then it says further, the prosecutors sat mute and permitted the court to attempt to interrogate and intimidate another member of the bar who reported a violation of law. Let me move it up so y'all can see what I'm reading. Also promoted the court wrongful conduct by asserting that the ex parte meeting was proper. 13. The court denied Mr. Williams and undersigned counsel their due process rights, as undersigned counsel has a right to adequate notice and to be heard, to call witnesses at a hearing, and to be represented by counsel for the entirety of the contempt proceeding, and Mr. Williams had the right to learn of all facts and circumstances of this crucial stage of the proceedings that occurred in his absence ex parte. 14. The court abused its authority by holding undersigned counsel in contempt for refusing to privileges information, to hold on to privileges information, and for protecting Mr. Williams' constitutional right to due process, right to fair trial, and right to fair trial, right to be present and effective assistance of counsel. This court refusal to acknowledge these rights and protection has created an unfair bias upon bias against Mr. Williams and his counsel, and favoritism toward the prosecutors. I think a lot of people are saying that. I've been seeing a lot of that. And then it gives court cases. Okay, 16. The record also reveals numerous instances during trial where the judge's behavior appears to have been biased against Mr. Williams' counsel and partially in favor of the state. Then it gives cases of this type of stuff. Let's go down. Okay, let's see. Okay, just giving court cases. It's repeating the same thing, but it's giving court cases to reference everything. Let's see here. Okay, 24. This court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand juries, bias, partial, potential sentencer, and thus must be removed from this case. Wow. You judge, jury, everybody. Okay. Okay. 26. This court conduct raises a strong finding that it has become personally embroiled in the case. It is clear, even to a casual observer, that this court involvement in this controversy requires this court be disqualified, recused, removed from all further proceedings in the above referenced case. And another judge who will duly exercise the power of the judicial branch with clarity and fairness must be appointed to this case. And it gives a case number where, they just always reference case numbers. It is crucial to the functioning of our court that the public believe, where did I go? Public integrity and of its judge and judicial fresco. I'm just reading through. This is another court case. Okay, y'all. Some of the stuff we can pass through. Juicy stuff. Okay, 31. Reference court cases. Indictment. Okay, 33. Let me move this up here so we can see. Judge Glanville, lawyer, and lawyers for the state, Love and Hilton, will be called as witnesses at trial for the jury to understand this ex parte meeting and determine demeanor and credibility. Additionally, Mr. Williams demands all ex parte meeting to be disclosed and standard in order to properly reveal the full extent of all violations of law and ethics. Again, lawyers for the Judge Glanville are necessary witnesses at this hearing and trial to determine the correctness of the motion for mistrial goaded by the conduct of these parties / judge. So they pulling all of their cards. Okay. Okay, then you know how they was referencing Exhibit A and so on and B, well this is it. Exhibit A. Okay, so Exhibit A is about when he incarcerated the attorney Brian Steele. That's what he's saying is wrong. He should have never did that. Okay, let's see what Exhibit B is. Okay, so that's part of that too. And Exhibit B is where another lawyer as well stated that and okay, certification of service. Okay, so he did that on yesterday. So what is you guys' thoughts and opinions on this? Looks like he's going after the judge to get him removed. I know he only had 5 days to do this, and he did it. And he's even going after the prosecution team as well, and he wants the jury to know what they did. And basically what they did is threaten Woody to jail indefinitely if he didn't testify. And Woody was like, well, I'm a lie. And they was like, well, okay. And still wanted him up there, and they shouldn't have done that. And if you guys recall, Woody fired his attorney because the attorney that was in there and she let this happen. And he was like, "You fired. Why? You didn't even help me. You didn't, fight for me." Because he wanted to plead the Fifth Amendment, and they was like, "Well, we're giving you immunity." But Woody's whole thing was, "You giving me immunity, but it's only for the state, not federal. So I can get up on that stand, and if the feds turn around and pick up this case, guess what? They can on that stand against me and prosecute me. So that's why he didn't want to testify, you guys. That's all it is. What they say, put it all up in a nutshell. Okay. Comment below. Let me know your thoughts. And don't forget to hit the like and subscribe. And thank you for tuning in.